Okay, today's presentation is going to be primarily geared towards California residential landlords. Obviously, tenants could benefit from this as well in order to keep your landlord honest, but this is going to be a quick overview of your obligations as a California residential landlord with 3 or more residential units that are elevated off the ground, which I'll get into specifically as what qualifies for this law and what your obligations are. But as a quick overview, I have to say that I am not an attorney. I am an attorney. And if you want to hire me, that's great. I'll provide my information at the end, but don't rely on YouTube for legal advice. Every situation is different. And just because you can get an answer online doesn't mean you're getting the correct answer. So let's get right into it. The primary citations are on the screen, SB 721, as well as the Health and Safety Code section 17973, if you want to get the specific legislative language. Now, what is California's balcony inspection law? Well, SB 721, which governs California's balcony inspection law, was signed by Governor Brown following that infamous 2015 balcony collapse in Berkeley. I'll talk about that in a moment. It was devastating. What must the inspection cover? Well, the inspection required by this law must at a minimum include the identification of each exterior elevated element or associated waterproofing elements that, if found to be defective, decayed, or deteriorated to the extent that it does not meet its load requirements, would, in the opinion of the building inspector, constitute a threat to the health and safety of the occupants. Now, associated waterproofing elements specifically means like flashings, membranes, coatings, and sealants that protect the load-bearing components of exterior elevated elements from exposure to the water and the elements. Now, assessments of elevated elements using methods allowing for evaluation of their performance by direct visual examination or comparable methods of evaluating their performance are allowed. Now, for purposes of this section, a sample of at least 15% of each type of exterior elevated element shall be inspected. Now, whenever you see the word shall versus should, you should understand that there's a significant difference. One is a mandate, the latter would be a recommendation. Now, this evaluation and assessment shall address each of the following as of the date of the evaluation: the current condition of the exterior elevated elements, expectations of future performance and projected service life, recommendations of any further inspection necessary, and recommendations of any necessary repair or replacement. Now, the report the inspector is conducting shall produce an initial report and a final report. So 2 reports. And the final report should indicate that any required repairs have been completed. Now, a written report of the evaluation stamped or signed by the inspector presented to the owner of the building or owner's designated agent within 45 days of completion of the inspection is required. And this report shall include photographs, any test results, and any narrative sufficient to establish a baseline of the condition of the components inspected that can be compared to the results of subsequent inspection. So that's creating this baseline as early as possible. And that's why there's a deadline for compliance. I'll talk about that under the when slide. But as the building ages, because everything and every one of us is always aging, it's going to get presumably worse until it's repaired or improved. And that's why you need that baseline initial inspection. So in addition to the evaluation required by this section, the report shall advise which, if any, exterior elevated element poses an immediate threat to the safety of the occupants, and whether preventing occupant access or conducting emergency repairs, including shoring, are necessary. Now, a copy of the inspection report must be presented to the owner of the building within 45 days of the completion of the inspection. And the law, SB 721, requires that if the inspection reveals conditions that pose an immediate hazard to the safety of the occupants, the inspection report must be delivered to the owner of the building within 15 days, and emergency repairs must be undertaken as specified with notice given to the local enforcement agency. So these requirements are pretty onerous, but as onerous as they are, it's even worse if you don't comply. And I have already spoken to a few landlords, unfortunately, that have decided it's just in their interest to do nothing and then, I guess, wait to get a fine and assessment and potential lien on their property. That's not recommended. It's always better to comply with the law than deal with the fallout, in my opinion. Now, what if repairs are required? So if there's an immediate threat, and if, for example, an exterior elevated element that the inspector advises poses an immediate threat to the safety of the occupants, or finds that preventing occupant access or emergency repairs, including shoring or both, are necessary, then that shall be considered an emergency condition, and the owner of the building shall perform required preventative measures immediately. And then immediately preventing occupant access to the exterior elevated element until emergency repairs can be completed constitutes compliance with that part of the law. Now, repairs of emergency conditions shall comply with the requirements of the law and be inspected by the inspector and reported to the local enforcement agency. And if there's no immediate threat, well, then the owner of the building that requires the corrective work to an exterior elevated element, in the opinion of the inspector, does not pose an immediate threat to the safety of the occupants. That's what we're talking about when there's no immediate threat. And in that case, the owner shall apply for a permit within 120 days of receipt of the inspection report. Now, once the permit is approved, the owner of the building shall have 120 days to make the repairs, unless an extension of time is granted by the local enforcement agency. Now, if the owner of the building does not comply with the repair requirements within 180 days, then the inspector shall notify. This is the inspector doing this without the building owner's permission. This is a mandate that the inspector shall comply with. So the inspector shall notify the local enforcement agency and the owner of the building. And again, if within 30 days of the date of the notice the repairs are not completed, the owner of the building shall be assessed a civil penalty based on a fee of at least $100 up to $500 per day until the repairs are completed, unless an extension of time is granted by the local enforcement agency. And sorry about the light on my face. I know it's kind of awkward. I should probably just move so it's not, so it's either all shadow or all light. Okay, hopefully that's a little better. Now, if a civil penalty is assessed, then a building safety lien may be recorded against the property. So it's very important that you comply if it's, violation or immediate threat. It's still important that you comply if it's no immediate threat, because you still could be fined, but obviously the former is urgent. All right, now let's get into the why. Now, forgive me for using such a gruesome image, but I wanted to really emphasize the severity of balcony inspections and balcony compliance, because this is what happens when you neglect something as critical as an elevated walkway or standing area, and because of dry rot, the thing collapses. People will become seriously injured. People will actually, and unfortunately, die a very gruesome death. So SB 721, as I said earlier, was put in response to that balcony collapse in Berkeley, directly in response to it. Now, in that case, the balcony collapsed due to decayed wooden joists, and 6 young college students were killed. And I think they were visiting from Ireland. I don't think they were UC Berkeley students. I think it was an exchange program. Not that it makes any kind of difference. And then 7 others were injured. And some of the local governments, already imposed a local inspection program, but this law created a statewide inspection requirement for certain balconies all throughout California. All right, now who? So who can perform the inspections, and who does this law apply to? Well, first, who can perform the inspections? A licensed architect, or a licensed civil or structural engineer, or a general contractor, but that general contractor has to hold any or all A, B, or C5 licenses that are issued by the CSLB, the Contractor State License Board, with a minimum of 5 years experience in constructing multi-story wood frame buildings. So this is another money-making opportunity, another job opportunity if you are a licensed architect, a licensed civil or structural engineer, or a general contractor meeting those qualifications, as well as individuals certified as a building inspector or building official as specified, as long as these individuals are not employed by the local jurisdiction while performing the inspections, because obviously that would be a conflict of interest. So who keeps the report? Copies of all inspection reports shall be maintained in the building owner's permanent records for no less than 2 inspection cycles, and shall be disclosed and delivered to the buyer at the time of any subsequent sale of the building. So that's another reason landlords need to do these inspections, as well as keep the inspection reports, because if you haven't done that and we're well beyond the deadline when this comes to be, when you're selling the property, that might be prima facie indication of other negligence, other requirements that were not met. That is not a path of inquiry that you want to open as a landlord. Now, who does this law apply to? Well, it's applying to, when I say who, I mean, what buildings. It's applying to buildings that have 3 or more units. And these are units that are that have balconies. So they have to be, there's more than just balconies, but they have elevated surfaces, elevated walkways, etc. If you don't have any balconies, you just have a multi-story 3+ unit building, and there's no place for people to reside outside on an elevated structure, there's no walkways, etc., you might be okay not having this law apply to you. But check with an attorney first. Definitely check. Now, when? So when must the owners be in compliance, and what are their recurrent obligations? So when must the buildings be inspected for the initial compliance? Now, inspections of the balconies, the decks, porches, stairways, walkways, and entries, as described above, must be inspected by January 1st, 2025, with certain exceptions, and it requires subsequent inspections every 6 years. So on that previous slide, it's going to be very rare that a building with 2 or more floors doesn't have at least a walkway or stairway that's elevated. So make sure that, again, you speak with an attorney before you assume that your property is exempt from the compliance mandate. And then make sure that you get a subsequent inspection every 6 years, and make sure that you document all of your inspection history. It's only for your advantage. Now, the inspection of a building for which a building permit application has been submitted on or after January 1st, 2019, shall occur no later than 6 years following issuance of the certificate of occupancy from the local jurisdiction, and shall otherwise comply with the provisions of this law. And if the property was inspected within 3 years prior to January 1st, 2019, by an appropriate inspector that meets those earlier qualifications, and the report was issued stating that the elevated exterior elements and associated waterproofing elements are in proper working condition and do not pose any kind of threat to the health and safety of the public, then no new inspection shall be required until January 1st, 2025. Now, in addition, buildings that are proposed for conversion to condominiums to be sold to the public after January 1st, 2019 must be inspected prior to the first close of escrow. So, again, the deadline, absolute deadline, is January 1st, 2025. If you meet one of those exceptions, such as the building permit was submitted after January 1st, 2019, then you can comply no later than 6 years following that. But for everybody else, January 1st, 2025, that's a Wednesday, as you can see on the screen, is your compliance date. Now, wrapping up, which buildings must be inspected are SB 721. So these are buildings that have 3 or more units that have, as I said earlier, balconies, decks, porches, stairways, walkways, and entry structures that extend beyond exterior walls of the building and that rely in whole or in substantial part on wood or wood-based products for structural support or stability, and a walking surface that is elevated more than 6 feet above the ground, as well as balconies designed for human occupancy or use. So that encompasses most buildings that are 3 or more units and have 2 or more floors, or maybe even 1 floor, but it has elevated platforms that are 6 feet or more, specifically more than 6 feet above the ground. That's possible that a single story building, especially ones that have, porches that are elevated in some way. I've seen that before on single story dwellings. Make sure you get those inspected if you have 3 or more units. All right, so that's it. So conclusion, make sure that you check your local government regulations, because the local government regulations can be even more strict, such as the state law, which requires these basic mandates. But the state law, SB 721, provides that the governing body of any city, county, or city and county, may enact ordinances or laws imposing requirements greater than those imposed by this law, SB 721. All right, so if you found this helpful, I would really appreciate it if you let me know. Obviously, I put some time into this. I'm not asking for any compensation. I'm not even asking, for you to hire me as your attorney. If you do want to hire me, my website is nickcohenmeyer.com. That's spelled nickcohenmeyer.com. Or if you wanted to see a flex of my phonetic alphabet, November, India, Charlie Kilo, Charlie Oscar Hotel, Echo November, Mike Echo Yankee Echo Romeo.com. And I make these videos because I don't want you to learn the law the hard way as a defendant. If there are other topics you'd like me to discuss, please let me know through the comments. And I would really appreciate if you gave me some feedback. I always want to improve, and I can already tell from this presentation that I have a few areas that I could improve, such as figuring out how to not block the text with this video bubble. All right. Thanks for forgiving me. Thanks for your time.